And then in 1982, we had the Charter, with which you are all familiar. And you're probably aware that the Supreme Court of Canada came up quite often in the debates leading to the adoption of the Charter, because what the Charter was proposing was a constitutional Bill of Rights, constitutional Aboriginal rights. And people were worried that this would end parliamentary supremacy, that it would give the courts de facto power over a huge area of the law where they had previously not had power. And so the debates went back and forth, and ultimately the compromise, as you know, was Section 33 of the Charter, which provides for a legislative override. In fact, it's been very seldom used, but that was the guarantee that gave people the confidence that in a pinch, if the courts kept getting it wrong, Parliament or the legislatures could override and constitutional democracy would be maintained. It wasn't clear when the Charter was adopted what the court's approach would be, because, and in fact many people were skeptical that the court would do much at all with the Charter and with rights. There had been previously a Bill of Rights, a legislative Bill of Rights, but one which purported to have what they call quasi-constitutional status, now associated with provincial bills of rights. And yet the court of the time interpreted it, for the most part, quite narrowly. So many pundits predicted that the same would happen to the Charter of Rights and Freedoms. But that was not to be. The court, with such luminaries as Chief Justice Dixon, Justice Wilson, Justice Lemaire, Justice McIntyre, and I could go on, pronounced that, as you well know, there would be a purposive and generous approach to the rights set out in the Charter, while recognizing at the same time that there has to be a balance under Section 1. There can be limits on those rights as required, as is justifiable in terms of a broader public interest. That has been the approach which has guided the court, basically, to the present. People find swings here and swings there, but I think my own assessment is that that approach has continued to guide the court to the present. And our court, as a consequence, has become an even more important institution in the Canadian constitutional realm than it might otherwise have been. But I hope one that exercises its power responsibly for the good of all Canadians. So that, in a nutshell, is a brief history. What about the work of the court? Now, when the Charter came in, the work of the court increased enormously. And so the court at that time was facing not only a challenge in how it would go about interpreting this new body of law, but how it would institutionally handle all the new work. And at the time, extensive rule changes were brought into place. We have time limits. We changed the leave procedure to mainly a written procedure rather than one that depended on oral hearings. Interveners to prevent other points of view were allowed. These were just some of the changes that took place. And even so, in the first years of the Charter, the court really struggled under a tremendous workload and even backlogs. Now I'm happy to say we don't have any backlogs, and we're able to handle the work. The leave process means that most of the cases we get, with some exceptions under the Criminal Code, are cases we choose. But our statute directs us how to do that. The Supreme Court Act says that we should grant leave on cases of public importance, because our function as Supreme Court of Canada is to resolve the difficult legal issues of the country on matters of public importance. That doesn't mean that it has to be important to everybody in Canada or every province of Canada. It means that it has to be of significant public importance wherever it arises. Just to give you an idea of our work, last year criminal cases, and some of these involved Charter issues, 39% of our work. Charter civil cases, 10%. That would be division of powers, which seems to be becoming very important in recent years. And I'm sorry, Charter of Rights, civil cases was 10%, division of powers is 6%, and then there's administrative law, civil law, torts, and other cases, family law, commercial and corporate law is 6%, taxes 6%, administrative law 4%. We also hear a number of Aboriginal law cases every year. So that's how it breaks down. It's not dominated by the Charter, but the Charter remains a significant part of our work. But basically, any legal issue that arises in any court in the country could come, conceivably, before us. Let me talk for a minute about the composition of the court. Well, gradually over the years, the court's composition was increased from 5 to 7 to 9 in 1949 and remains at 9 today. Until the 1970s, the court was all white and all male without exception. Bertha Wilson was appointed as the first female justice in the late 1970s. Claire Leroux-Dubé came after that, and in 1989 I was appointed. So then we had 3 of 6 judges as women. When I was sworn in on the Supreme Court of Canada, and I had just taken my oath, and I sat down, and Bertha Wilson leaned over and whispered to me, 3 down, 6 to go. So I thought that was pretty funny. A couple of weeks later, I was in Edmonton, and I was making my maiden speech as the new justice of the court, and I told that story. Well, there was an irate letter to the editor. What does this new judge think she's doing, suggesting that there could be an all-female Supreme Court? And you know, I felt, oh my, I've made a terrible mistake, and I worried about it. And then I thought, well, for over 100 years it was all men. Would the country really come to a terrible end if for a little while it was all women? Anyway, I comforted myself with that thought. And we now have 4 of the 9 justices are women. And I have to say, on a personal note, that it's a wonderful place to work because it's an atmosphere where you never even suspect that anyone would be thinking, oh, she's taking that position because she's a woman or whatever it might be. It's a gender-neutral working atmosphere, and I have to say for the first time in my life, which is wonderful, and I'm very proud of the fact that we have both men and women of great integrity and in roughly equal numbers on the court. Now, the court is supported of a staff, with a staff of something under 200. We do a lot of things that weren't done in the early days. We publish Supreme Court reports, so we have an editorial board. Everything we do, because we function in 2 languages, French and English, is done in 2 languages. So we have a translation bureau. We have a law branch to assist us in preparation of memoranda on the leave applications and other matters relating to the rules and so on. And of course, as I mentioned earlier, each justice has 3 law clerks. And for the students in this audience, I would encourage you to think of spending a year at the Supreme Court of Canada clerking. I think I am not out of line to say that most of the clerks say that it's the best year of their life, certainly one of the best years of their life. It's a year when they are they're confronted with many, many interesting legal issues, when they get to work with the justices, when they meet 26 other brilliant young lawyers from across the country. It really is a very good experience, and we try to make it an educational experience. And we as justices love our clerks and often end up with very long-term friendships and relationships with them. So that's just a little promo on the side. That's not why the dean asked me here, but